Jake Light here, gaming lawyer at your service. Whether you're a fresh graduate just having found a company to work at, or someone that's been working in the same industry for decades, we can all agree that not all employers actually know what terms and conditions to put in agreements, or worse, not even providing you a contract for you to sign when they hired you. So today, I'm going to explain to you what employment contracts are and why are they important to employees to understand. And before I start, I would like to emphasize that information provided in this video is for education and entertainment purposes only. Briefly explaining, employment contracts or agreements are written documents with terms that inform you of what you, as an employee, must do for the employer and what the employer is willing to provide you in return. For most folks, they are called different things like appointment letters, letter offers, or contract letters, but they all mean the same. In practice, employment contracts are normally drafted by employers unilaterally and handed to the employee to just sign quickly. And I should stress this strongly before I go on. Don't sign any contract before you fully understand it. Like any agreements in writing, signing is the same as you saying, "I fully agree to be legally bound by terms in it." It is unfortunately common to find employers giving you a short deadline to sign an agreement, or won't let you have a copy of the contract to browse through. If that happens, it's already a red flag for you to question them. Why are they in such a hurry to seal the deal? So yeah, always ask for the time to read the terms and have someone experienced help you check. So now we know what employment contracts are. What terms should they contain? Well, the general rule is, the more detailed and simply worded an agreement is, the better, because it will provide clear understanding of both parties' contractual rights and obligations. Despite how employers may try to convince you otherwise, contracts are always negotiable and renegotiable at any given time, and there are 4 broad categories of content of which an agreement should contain and be negotiated with. Number 1. Pecuniary compensation is all that cash money employer must pay you directly. Number 2. Non-pecuniary compensation is anything but cash that employer must provide you. Number 3. Job scope is what kind of work you need to do, when and where you will be working. Number 4. Termination of contract is when and how you can resign or get dismissed by your boss. I won't dive deep into each one of them for now, because there are fundamental issues related to them that deserve their own videos to be discussed about. Suffice to say, if you don't see these categories of terms in the contract, and you have heard your employer promising you something that's not mentioned in the terms, best of you to bring it up with your employer ASAP, before they bring out the "Huh? I don't remember promising you that," or
"Remind me about it next meeting."
And maybe even,
"Yeah, so what? You're gonna sue me?"
I can already imagine some of you asking,
"But Jake, what if my boss doesn't follow the contract and cut my salary? Wouldn't it be pointless to have a contract then?"
Don't worry too much, you're still relatively fine. Whatever your employer has breached, it should be clear to everyone now that you have something to refer to. And from this point, you can decide whether you want to talk things out and things peacefully by resigning, or take legal actions against the employer as a last resort. Either way, it's way better than just being able to claim,
"They verbally promised not to cut my salary,"
to the judge. But here's the confusing part of the employment law. What happens if there's no employment contract? Well, usually this is where the statute laws or court decisions come in to help tell what the employees and employers' rights and obligations are. That said, different countries have differing levels of protection to employees. In United States of America, the land of freedom, is also free of many employment protections. Barring statute laws that make any discriminatory actions illegal, it is federally legal for US citizens to work without employment contracts, which are referred to as at-will employment. The main perk for employees is that either parties have no obligation to serve any notice to terminate employment, which can be good or bad depending on who you ask. While on the other side, most states in Malaysia are required by federal law to have employment contracts to be in writing if the working period exceeds more than 1 month. And the Malaysian Employment Act 1955 states what general terms should an employment contract contain. But sadly, most of these legal rights are only applicable for employees earning 2,000 ringgit or less per month and for specific types of employee work. And for the majority of other employees, their legal rights are limited to not being unfairly dismissed by employers. Either way, with no employment contracts and no laws to list out important terms, you will only have assumptions of what you and your employer should be doing for each other, which the employer, being the one that pays your salary, has the bargaining power to subvert them whether it's legally allowed or not. Just to name a few instances, employers can delay paying salary, deduct annual leaves, reduce medical claims, falsely accuse employee of misconduct, or fire you without giving any reason or notice. Of course, I get that some people don't care if their bosses could treat them badly as long as they can freely come and go as they want. But for those that have families to feed and debts to pay, we should really think about giving ourselves a level of certainty when we work. Despite all of that I have mentioned, at the end you were told that the contract is non-negotiable or that there is no need for one. What can you realistically do in this situation? Well, you would need to critically consider whether the job is worth it. Even though there's a high chance your employer might be exploiting you, always keep in mind the relationship of employers and employees are not on equal footing. Employers often have the advantage of time, money, influence, or authority to persuade you into working for them. There could be many reasons why they don't want to negotiate or prepare an agreement, but assume none of them are for your benefit. So there's that. To summarize, employment contracts are always better compared to having none. More terms in a contract means better clarity and understanding of your work. Laws do not prevent employers from infringing employment rights. When you don't have a written agreement, you're at the whims of the employer. When employers breach contracts, you have more options available to take. Employers that are reluctant to negotiate or prepare employment contracts are huge red flags. Thanks for watching. I hope you haven't gotten sick of hearing me repeat the words like employment, employer, and employee, because I regretfully still have more to talk about on the subject in future episodes. If you have any questions or criticisms about today's lesson, please comment and let me know, or you can find me at our Discord community server Light & Co Gaming Aid Center. Link is in the description below. Until next time, be hopeful but stay critical. As an employee must do for the employer. As an employee must do for the... As an employee must do... As an employee must do for the employer... As an employee must do for the employer. If that happens, it's already a red flag for you. If that happens, it's already a red... If that happens, it's already a red flag for you to call it. It's already a red flag. Always. So now we know what. Because it will provide clear understanding of both parties' contractual rights and obligations. The main perk for employees. The main perk for employees is that either parties have no obligation to serve any notice to This is a mouthful. Most states in Malaysia are required by federal law. Most states in Malaysia are required by federal law. Most states in Malaysia are required by federal law. Most states in Malaysia are required by federal law. Most states in Malaysia are required by federal law to have employment contracts to be in writing if the